Good evening. My name is David Bubis, Director of Philanthropy at Public Counsel. Welcome to Public Counsel's fourth Hour of Justice panel discussion, where we have been exploring a variety of legal and social issues and challenges facing our community and country. Thank you all for joining us tonight. Before I introduce tonight's topic and panel, I want to thank and acknowledge the co-sponsors of our series, the Beverly Hills Bar Association, the Daily Journal, the LA chapter of the Federal Bar Association, LA County Bar Association, and the Mexican American Bar Association. We appreciate your support and for your assistance in getting the word out about our Hour of Justice discussions. As you may be aware, Public Counsel is celebrating its 50th anniversary. Public Counsel is the largest pro bono law firm in the nation. We work with major law firms and corporations to change people's futures. Our 140 staff, made up of attorneys, social workers, and support staff, along with 5,000 volunteer lawyers, law students, and others, assist over 30,000 children, youth, families, and community organizations each year. Our activities are far-ranging and impact a wide spectrum of people who live at or below the poverty level. Tonight, we will focus on the role of the federal and to some extent the state courts in addressing a variety of inequities and inequalities in our society. Tonight's panel discussion is entitled, "Can We Count on the Courts for Justice?" A conversation about racism, sexism, homophobia, presidential authority, poverty, and the Supreme Court. No more, no less. This evening's panel will turn our attention to the role of federal courts in addressing some of our nation's most intractable and complicated issues. While time does not permit a deep dive into all the possible subject areas listed, we do have an outstanding panel to assist us to at least begin the conversation. It's my pleasure to introduce them now, along with our moderator. For purposes of brevity, I will provide a very brief intro for each of our panelists. For their complete bios, please visit hourofjustice.org. First off, Erwin Chemerinsky is the Dean of the UC Berkeley School of Law and the Jesse H. Chopra Distinguished Professor of Law. Michelle Goodwin is a Chancellor's Professor at the University of California, Irvine School of Law and founding director of the Center for Biotechnology and Global Health Policy. Mark Rosenbaum is Director of Public Counsel's Opportunity Under Law, which aims to eliminate economic injustice. And I must just add, recently Mark was named as one of Daily Journal's top lawyers of the decade. I couldn't resist Mark. And finally, our moderator tonight is Tanya Acker. Tanya is a co-host of the twice Emmy-nominated Hot Bench. Tanya Acker is also the host of Tanya Acker Show podcast, and she is a proud officer and member of the board of directors of Public Counsel. So a quick word about our format tonight. Tanya will be moderating our discussion for about 45 minutes. At about 6:45 or so, we'll give you all an opportunity to ask the panelists questions via the chat function on YouTube until we end at 7 p.m. Please don't wait until 6:45 to ask your questions. Go ahead and write them in as we go along. We'll be monitoring them and passing along as many questions as possible to Tanya. Thank you, panelists, for being here. We could not have asked for a more impressive panel for our topic tonight. And without further ado, I pass the baton off to Tanya.
Thank you, David. Thank you, everyone, for being here tonight. And on behalf of my colleagues at Public Counsel, we appreciate you joining us tonight for this important conversation, which will only touch the surface. So I'm going to jump right into it. We are exiting what might be graciously and generously described as one of the most regressive periods in modern presidential politics. And we are leaving a presidency in which the last incumbent appointed more than 200 new judges to the federal bench. Some very young judges, some judges who will not advance or at least embrace or acknowledge, I'll put it like that, the power of such precedents as Brown v. Board of Education, judges who have the power to transform judicial norms for at least a generation. Public Counsel has certainly been able to push back on some of that. We've had some incredible wins in the era of education, for instance, with our partners at Irell and Manella and Sidley and Austin and other law firms. But are these victories that we've had, victories such as those in Michigan, where we were able to establish the right to an education, victories in California, where we've been able to get decision makers to acknowledge the power and force of trauma and how that impacts the lives of children trying to be educated. Are these anomalies? Is there still a path for justice in the courts? I'm going to start with you, Professor Goodwin.
Thank you very much for the question. It's an honor and a privilege to be with you and this wonderful audience and with my colleagues here. You know, the courts are an important part of our government, and I think it's important that we not lose hope. And yet at the same time, it's important that we stare in the face exactly what you are speaking to, right? During the Trump administration, Donald Trump was able to nominate and through Mitch McConnell in the Senate get confirmed more federal judges than any other president save George Washington. It's important to note that if we look at that in terms of demographic, overwhelmingly they were white and male. At least as of July or August of last year, there were none for the federal appellate courts that were African American that he had nominated. Only a few Latinx judges, if that, for the federal circuit courts of appeal. And so what you're speaking to, both in terms of age and the likelihood that these are individuals who will be on the court for a very long time, the background of these individuals, some that were deemed to be unqualified by the American Bar Association and even by their local state bar associations, and many of whom had no hesitation in showing that they were cautious about the precedential value of Brown, and beyond Brown, Roe v. Wade. So there's a lot to be concerned about. But I will say this as well. So all of that is deeply disconcerting. Absolutely. What's also interesting to balance out that picture is to think about the challenges to the 2020 presidential election that was launched by Donald Trump. There were more than 60 cases that were litigated, and a number of Trump-appointed judges pushed back. He was not able to gain any kind of leverage through these judges who struck down or who said there was no sufficient evidence for the claims that were made by Trump and his team. So I think that all must be, sort of together in a conversation. And one last piece that I will add is that it's not just the federal courts for which we should be concerned. We also should be very much concerned about the state courts too. And we are in a period of COVID. And as one just thinks about what happened with the Wisconsin State Supreme Court in the cases that involve voting, the primary voting during COVID, and the challenges to the regulations, or the challenges that between the legislature and the governor that played out in the Wisconsin Supreme Court and then that played out in the U.S. Supreme Court, are very telling, because it was disappointing not just at the Supreme Court level, but also at the state level too. So I think all of that needs to be placed on the table in this conversation. And then I'll boot it over to Erwin Chemerinsky, my frequent co-author.
Dean Chemerinsky, can we trust this court? We recognize the fact that it is not always operated in lockstep. We saw a decision recently where they said to the former president, you got to show your tax returns. Does that mean, and as Professor Goodwin pointed out, we've seen a number of decisions, at least with respect to the election, where they did not act in lockstep with their appointer. Is the federal judiciary still open for business?
Yes, of course, the federal judiciary is still open for business. I want to say that it's such a pleasure to be part of this panel. To go back to the question you posed at the beginning, the path for justice exists in the court, but it's going to be a difficult path for some time to come. Donald Trump appointed 1/3 of the Supreme Court, over 1/4 of the Federal Court of Appeals and district court judges who are sitting. Focus on the Supreme Court. It is the most conservative Supreme Court that there's been since the 1930s. It's as conservative as any court there's been in American history. You have 5 very far-right justices: Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. You have a moderate conservative in John Roberts. You have 2 moderate liberals in Breyer and Kagan, and 1 quite liberal justice in Sotomayor. This isn't going to change likely for some time to come. Consider the ages of the conservative justices. Amy Coney Barrett is 48 years old. If she remains on the court until she's 87, that's the age which Justice Ginsburg died, Barrett will be a Supreme Court justice into the year 2059. Neil Gorsuch is 53, Brett Kavanaugh is 55, John Roberts just turned 66, Sam Alito is 70, Clarence Thomas is 72. I think the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. It's easy to imagine 5 or 6 of these justices being together for another decade or two. And as Michelle pointed out, not only did Donald Trump appoint over a quarter of the lower federal court judges, but he appointed very young judges, judges who are overwhelmingly white, judges who are overwhelmingly male, and judges who overwhelmingly were very conservative. They're going to be on these courts for a long time to come. So what is the path towards justice? Suggest 3 things quickly. The first is creative lawyering. And public counsel has the most creative lawyer and the best lawyer who I've ever met in Mark Rosenbaum. If you want to talk about the Michigan case where the Sixth Circuit found a right to literacy, it was Mark Rosenbaum who was the architect of that litigation. Or if you want to talk about the trauma lawsuits, it's Mark Rosenbaum who's the architect of that. Whenever I have an important case, say in the Supreme Court, the first person I call to be my co-counsel is Mark, and public counsel is so fortunate to have him. So if anybody can find this path to using the federal courts for justice, it's Mark. Second, we need to turn to state courts much more often than before. And certainly I know that Mark and public counsel do this. In 1977, William Brennan wrote an article in the Harvard Law Review urging more use of state courts and state constitutions. I think it's going to be difficult to protect a right to education under the United States Constitution, given Supreme Court precedents. But many states in their state constitutions enumerate a right to education. And some of Mark's most successful litigation with regard to education has been in state courts. And third, we're going to need to use the political process in much better and more creative ways than ever before. Things that perhaps before might want to turn to the courts, now we need to use the political process. We have a progressive state legislature in California. There's a progressive board of supervisors in Los Angeles County. The Democrats have a majority in the House and the Senate, as well as the White House. Now is the time to be pushing a legislative agenda for justice in addition to using the courts.
Let's turn to our friend and colleague, Mark Rosenbaum, who can perhaps give us some advice on what it means and how you be a creative lawyer in a judicial environment that is not necessarily so receptive to the creative principles that we're trying to advance. Mark, what do you say?
Well, first I say good evening to everybody, and what a privilege it is to be with Erwin and Michelle. I very much appreciate the kind words, but they are on my speed dial, and we are all walking in their shadow in terms of the scholarship and the thinking that they have done. I want to say a couple things in response. I certainly agree with all that Michelle and Erwin said, but I also want to remind us that the problem with the federal courts didn't begin with the Trump administration. Issues like systemic racism, police abuse, voting rights, LGBTQ issues, those issues and the persons who are deeply affected by the inequities in the system right now, the federal courts were pretty much closed to all of those matters, even before the Trump judges took office. I also think, though, that there is a path, and I think we have no choice but to recognize and define what that path is. Historically, the courts have been there. They have been there when the political processes have not worked, and they have always been an important, vital instrument of the civil rights movement. And we don't have the luxury of giving up on them. I think there are some lessons from the cases that you were talking about, Tanya. Think, for example, of the DACA case. I appreciate, other lawyers appreciate the praise that comes to them, but let's be honest, lawyers did not win that case. That case was won because of a strong grassroots movement, because this country knew who those 700,000 individuals were, who respected their communities, because the Trump administration overplayed its hand in attempting to say to the federal court and the Supreme Court, you will be responsible for removing those individuals, because they had been part of a community struggle. As one DACA recipient said to me after we won the case, what was important was that we won it on our terms. We won it by establishing who we were and making America face that. I don't think that what John Roberts did in that case, and it's important to remember that was a 5-4 decision before the change in composition that Erwin and Michelle talked about. But that was about the integrity of the court and whether the court could maintain its place in our democracy if it turned its back on those individuals. Same thing with respect to the census case we worked on. That case originally came out the other way, but it was only when it was surfaced that everything that Secretary Ross and the United States government had said were lies, and it was part of a deliberate political effort to use the census for political purpose. Not a question of integrity, not a question of great lawyering in terms of novel legal theories, but a recognition that the integrity of the court, of the Supreme Court, depended on it. The literacy case, the Detroit case, I want to be honest about that. We escaped that case by the skin of our teeth. We won that case because a Democratic governor, Governor Whitmer, had run on the issue of literacy, in part because of the case, largely because going back to 1963 and the March on Freedom with Dr. King and Reverend Franklin had made education a part of a community struggle, and because the state government under Governor Snyder had been exposed as treating these kids as, quote, children with intellectual limitations. We got a settlement in that case, despite the fact that 6 Trump appointees to the Sixth Circuit and 6 more Republicans on that court wanted to overturn it, and it was a race to get that case settled. The other point I want to say, the last point I want to say goes to what Erwin and Michelle said, and that is we've got to begin to use the state courts even more for purposes of civil rights struggles. That is not part of our tradition in the same way. The California literacy case you mentioned, the trauma case you mentioned, they were won in state courts under state constitutions with state Supreme Courts that were interested in conversations that the federal courts have frankly closed their ears to. So I think the message is we have to continue to attach ourselves to popular grassroots movements so that it becomes extraordinarily difficult for the courts to say no to the claims for justice. And we have to broaden the outreach to the courts where we seek that justice to beyond just the federal courts themselves.
So let's pick apart a point that you just made, Mark, about sort of beating back some of the lies that are told in extrajudicial forums. And then also, Erwin, you talked about going to the legislature. So my question, and we'll start with Michelle, how open are these other arenas? I'm not talking about state courts now, but I'm talking about making use of other mechanisms. Erwin, you made this point. When we have seen, just look with respect to the big lie with respect to the 2020 election, we've seen legislatures, we've seen legislative bodies, or at least the leaders of certain legislative bodies embrace lies. And in one sense, it would be wonderful if we could all look at these other venues as a platform for justice. But in another sense, it also seems that the norms there are sort of controlled by who has the loudest voice, who's got the most Twitter followers, and who most controls social media. Is the law an effective weapon against these very loud extrajudicial voices that are uncontrolled, uncensored, and unfiltered? I want to start with you, Michelle.
Well, there are certainly limits to the law. And to Mark's point, if you think about the push that resulted in, it's not the only kind of source of building for the 2020 presidential election, but the tragic killing of George Floyd, which launched protests, not just in the United States, not just in Minneapolis, but around the world, had an important kind of force that really moved politicians to have to confront racism and white supremacy in the United States. But let me say this, we're in a space of a kind of tug and pull that's been going on for a while now, to Mark's point. And if you think about the backlash to Barack Obama, in many ways, we still are experiencing the reverberations of that. Journalists are now coming to recognize that they got it all wrong. They didn't want to see race. They didn't believe that race was involved in the rise of the Tea Party. The fact that the sort of glory days of Barack Obama were over as of 2010, when race became a significant factor, and we see the rise of the Tea Party, and we then see certain intersectional consequences that also take place at that same time that I think are important in these conversations, right? So we see an anti-voter movement, voter suppression taking place at state levels. You see the encroachments on reproductive health and rights at the state level. You see pushback against immigration at the state level. And so while that is also happening, what we've also seen is then the backlash to Donald Trump and the rise of women then and saying, we are going to take these seats in state legislatures. But you must also be mindful of the place in which they began. I mean, sadly and strangely, even though this is 2021 and you think that we'd be much further ahead, the United States has been notoriously behind both of the full representation of women in power as well as at the state level. So even though we saw pushback to Donald Trump, more women running for state offices, they were coming into spaces where women had only made up 5% of the legislature, 10% of the legislature, maybe 15% of the legislature. And so it's promising, and we must pivot. We absolutely should at the state level, because potential for doing the work that Irwin mentioned and utilizing states' constitutions is absolutely there. We need more done. We must be mindful of this tug and pull, even what we've seen in the 2020 presidential election. And here, if we look at the sort of pull from that, yes, we see the first woman of color as a vice president, first Black woman, first Asian woman, vice president. That's great. And Joe Biden in the presidency. But at the state level, 30 of the state legislatures are now Republican, controlled. And so that's also important to keep an eye on in the space of all of this. And let me just say one more thing, which is that while we talk about the courts and we talk about state legislatures, we need to talk about agencies as well. And so I'll end with that, and I'm sure we'll come back to talk about and sort out some more of these issues.
Erwin, how do we make better use of these other platforms that you've discussed when they don't have the filters? When you can show up at a hearing and lie with impunity, when a legislator can propound a lie unembarrassedly, how can normal folks make use of these platforms when, frankly, there are no rules to govern how you wage war in them?
Long ago, it was pointed out that the best remedy for the speech we don't like is more speech. The best remedy for false speech is true speech. And I think that what we've seen in the last few months is that true speech in law can overcome lies. They just did. I mean, we've just lived through the greatest threat that's existed to American democracy. Never before do we have an incumbent president trying to stay in power, notwithstanding having lost the bid for re-election. He did everything he could to spread lies. Talk about law. 61 courts heard his lawsuits. 60 of 61 ruled against him. And the one that ruled in his favor was on a very minor issue about allowing observers to watch the counting of votes. We saw election officials in places like Michigan and Georgia follow the law and pay no attention to the lies and the pressure. We saw state legislatures in places like Pennsylvania and Michigan stand up to the pressure. We even saw Mike Pence stand up to the pressure. We saw, I think, how fragile democracy is, but we also saw that the law and the guardrails of democracy work. I do think we need to use the political process, and we need, as Mark said, to mobilize at the grassroots to do that. Take things that Congress can do. My hope is that the tragic death of George Floyd, the protests in all 50 states, will cause Congress to adopt meaningful police reform, and they can. There's bills in Congress to eliminate the ability of police to use the chokehold that killed George Floyd and so many others, to eliminate not police entrance, to expand municipal liability for police misconduct, to change the law of qualified immunity. All of that can be done by Congress. In fact, those things can be done by the California legislature for this state. There's a bill in Congress to reform the political process, to restore the Voting Rights Act, to require independent districting commissions to stop partisan gerrymandering for House of Representatives elections. But we need to pressure our legislators at the federal level, the state level, and the local level to do these things.
Mark, so much of this turns on participation and ensuring everyone's participation. Public counsel certainly spearheaded a big victory in ensuring that President Trump was not able to discount a number of people as in the census. And all of this goes to how we make sure that everyone is counted and everyone participates. What role do the courts play in ensuring that participation is as broad as it needs to be to ensure that we remain a democracy?
Well, traditionally, the courts have been that's place. We know that in the 60s, when there were efforts to undermine political participation by those involved in the civil rights movement, by persons of color, it was the courts that made certain that those opportunities existed. I guess when I think about these things, Tanya, I do think it is easy to feel despair. At the same time, what we have on our side is justice and the truth. And you can't forget that. This isn't, these are not issues of moral relativism. For most of these issues, there really are not two sides. Either everybody gets an opportunity to vote or they don't. Either the police get an opportunity to murder persons of color, Black people, or they don't. Whether or not there are, in fact, voting rights, whether kids get a decent education so they can participate in a democracy. There are not two sides to those issues. And I think we need to cherish that, and we need to get those stories out. We won those cases that Erwin and Michelle won because we exposed the lies. Nobody is in favor of the lies. They are dangerous. They are toxic. They have punched major holes into our democracy, but they give us the opportunity to tell the truth, no matter what the arena is. And I think that's our business. I think that's our mission. I'm proud to be part of public counsel that has a multi-dimensional advocacy strategy. There are lots of great organizations out there that are doing similar sorts of advocacy. But you take one case in our lifetime, like the marriage case. The marriage case wasn't won because of a legal theory. The marriage case was won because by the time it got to the Supreme Court, there was no principled opposition to it. That's the story now. And for all the issues we care about, the ones that Erwin just ticked off, the ones that Michelle talked about, that is our job, to get the truth out. And the last thing I want to say is this: the federal courts have let us down. Again, long before the Trump courts, the federal courts said that there would be no remedy for systemic racism. The federal courts created the immunity that Erwin said out of whole cloth, that sanctioned and encouraged police abuse. The federal courts permitted presidential authority to go forward on pure animus, pure racist business. Our job is not only to resist that and to tell the fact that that is not the way a democracy operates, that is founded on lies, but it is an opportunity for us to go into progressive state courts and progressive state legislatures and say, you are not bound by these lie-filled doctrines. And this is an opportunity that I think to open up the courts to arenas that have been shut down. And frankly, we have been too shy, too we haven't shown the appropriate courage in order to fight these matters in those courts as well. I mean, the idea that you cannot address systemic racism when it is the single most toxic force in America today, that you cannot address it in federal courts, that is an outrage. That story has to be told, and that has to be the business of every advocacy group in every arena, including states' courts with friendly state constitutions.
Michelle, is there an avenue? Do you see an avenue in the court system to raise or address questions of systemic racism, or to bring to the fore facts that perhaps aren't well received in the larger political conversation? I mean, we've seen a lot of resistance in the political culture to conversations and discussions about systemic racism. People talk about the 1619 Project like it's a bad word. So how, given what Mark talked about in terms of these precedential resistance to treating racism as a systemic problem, is there room? And if you think there's room, how do we do it?
Well, it's a challenge, and I'm glad that you've raised that, because here this deals with the question of the social as well. As you say, the resistance to the 1619 Project caused quite a bit of pushback with the Trump administration and the launch of the 1776 Project and the pushback against equity, diversity, inclusion, and belonging training, despite the fact that we know very well in the United States that macroaggressions, microaggressions, implicit bias, explicit bias, we see that across a range of areas of American life. We see that in medicine, we see that in law, we see it in education, we see it in hiring, we see it in housing, and so much more. Is there promise and hope? You know, it seems that we've again had this push and pull dating back to the years almost immediately following the ratification of the 13th Amendment, 14th Amendment, and 15th Amendment. I mean, one issue for us to be clear about when we're thinking about criminal justice as a backdrop to this is that we still have in the federal Constitution the permissibility of slavery. Right there, right in the 13th Amendment, the very constitutional amendment that liberates liberates enslaved people to a place of freedom, except if you're convicted of a crime. And that important history associated with that, you have law schools where law students graduate from and have taken con law and have no idea that in the 13th Amendment, which abolishes slavery, keeps it there too. And then that there were state legislatures that ratified this within their state's constitutions. And what this meant was creating what we now would term misdemeanor laws. But at the time, in parts of the South, what this meant were things that were just so egregious that lasted through Jim Crow and in various ways last today. That, you know, if you were Black and you sold corn, this was a crime. You're Black and you sold wheat, this is a crime. If you're Black and there's two or more of you that stand on a corner, that is a crime. Here is the fine. It's $75. It's $100, $150. Imagine having some fine like that in 1866 that you're expected to pay. I mean, clearly it's a way of reintroducing people back into a reform of slavery. I mention that only to say that when you mention the 1619 Project, the kinds of resistance to full racial equality, is that we have actually seen that every time there is a step of progress, we've also seen efforts to pull back. And we have to be mindful about that in the United States. But I want to stay hopeful. I think it's important that we stay hopeful, and just add this, which I think is not irrelevant to our program, but I've been thinking about this for a while. I wonder what messages that enslaved Black mothers had to tell their children the night before auction in order to keep their children whole, in order to keep them hopeful, knowing very well that they would probably never see their children again, but had to somehow give to them a sense of courage, a sense of hope, a sense of integrity and dignity within themselves so that they would not internalize those messages of simply being chattel. So I think hope is very important, combined with the kind of strategic actions that Mark has taken and the kind of litigation efforts that Erwin has also undertaken.
Thank you for reminding us to be hopeful. Thank you for putting this conversation in the context of the history of the people who came before us, who frankly managed to find hope when the circumstances were far bleaker than those in which we find ourselves now. So speaking of hope, Erwin, let's look at the Sixth Circuit decision, where public counsel, along with Sidley and Austin and you and others, were able to help establish a right to an education. Is that not, I mean, if you look at that opinion, it really seems to try to poke some holes. It pokes some holes in parts of what keeps white supremacy alive. You keep white supremacy alive if you don't educate people, and if you don't allow people to the access to the resources that will allow them to reach their full potential. Is our decision and that great victory in the Sixth Circuit the beginning of some new momentum? Is that our new hope? You're on mute.
I hope so. What Michelle just said is so powerful in terms of a message of hope. In 1973, in San Antonio Board of Education versus Rodriguez, the Supreme Court said that education is not a fundamental right under the Constitution. And the court said that discrimination against poor children doesn't violate the Constitution. In light of this, it was a daunting task to find a way to challenge the horrific inequities and lack of literacy education in the Detroit schools. This was Mark Rosenbaum's idea, to litigate this as a right to literacy case and try to distinguish San Antonio Board of Education versus Rodriguez. And it worked. And the Sixth Circuit produced a terrific opinion. Now, I've got to also say, it was fortunate that Eric Clay and Jane Stranch were on that panel. I think if there had been 3 Trump appointees on the panel, it wouldn't have come out that way. It was fortunate that after the decision came down, that there was a Democratic governor, a Democratic school board in Michigan to settle the suit. I'm not hopeful that the Supreme Court would have affirmed the Sixth Circuit if it had gotten there. But because of creative lawyering, an enormously important victory was won. And the victory isn't just in terms of the law. The victory is in terms of hopefully what it will mean for the children in Detroit in improving their education. When I think of the other lawsuits that Mark has brought for education, they're so critical, because if ever we're going to be a more equal society, it's got to be through education. So yes, I think that decision provides a basis for hope, but I don't want to be naive and think that we have a United States Supreme Court that come to the same conclusion that the Sixth Circuit did in that case. Not right now, at least.
I think it's important, and we've got a great question. I'm going to go to it, but I think it's important to acknowledge the role of lawyers in fighting for justice and making sure that everybody, whether or not you are somebody who has folks who will go fight for you, or whether or not you're someone who doesn't, public counsel is really making sure that everybody gets heard in the first instance. So here's a great question. Can we expect, and we're going to go down the road, we'll start, we'll stay in order. We'll start with Michelle. Can we expect the Democrats to expand the Supreme Court, given the 2 seats that have been stolen recently? And that is from Corky Brown. So Michelle, are the Democrats going to get these 2 seats back that we remember Merrick Garland was denied a hearing? Amy Coney Barrett, I understood, was appointed to the Seventh Circuit in lieu of an African-American woman who might have had that seat and might have been on that path. Should the Democrats go add a couple of seats in order to, some say, level the playing field? What do you say?
I say that the Democrats should be far more attentive and aggressive than they have been. I'd say that we were in a space of of sound deliberation during the Carter administration, where we saw the expansion of women of color, people of color on the Supreme Court. I think we don't pay attention to what happened during the Carter administration, how he truly integrated many of the federal circuit courts of appeals. Of course, he was the president that nominated Ruth Bader Ginsburg to the DC Circuit Court of Appeals. She wasn't even the first woman that he nominated there. And the Democrats haven't put this at the forefront the same way that Republicans have. It was during Carter's administration that we actually saw an expansion of the courts themselves. So that's not unusual. Judges have said that they are overtaxed. There's more work for them to do than they have the capacities to do. So I think the arguments are actually there for an expansion of the courts. The efforts that Biden has taken to look at this in some meaningful, deliberative kind of way, I think is a good thing. But I think Democrats have to be smarter, intentional, and more aggressive and bold, quite honestly, about making sure that there is an equal playing field within our nation for access to our courts. And quite frankly, what that means is an access to justice. That is what is important.
Erwin, 2 seats? They're going to add 2 seats?
The Democrats should expand the size of the Supreme Court, but they're not going to be able to do so. Why should they? Well, the number of seats on the Supreme Court is not set by the Constitution. It's set by federal statute. It's ranged from 5 to 10 over the course of American history. 9 is a historic accident. In the late 1860s, it was 10, and there was a terribly unpopular president, Andrew Johnson. Congress didn't want him to fill a seat on the Supreme Court, especially right after he'd been impeached. So Congress said the next time there's a vacancy, we'll eliminate that seat. And it's been 9 ever since 1869. Since 1960, we've had 32 years with Republican presidents and 28 years with Democratic presidents. In 2024, we'll have had 32 years with Republicans and 32 years with Democratic presidents. Since 1960, Republican presidents have put 15 justices on the Supreme Court. Democratic presidents have put just 8 justices on the Supreme Court. Some of that's historic accident as to when vacancies occurred. Richard Nixon had 4 vacancies to fill in his first 2 years as president. Donald Trump had 3 vacancies to fill in his 4 years as president. Jimmy Carter had no vacancies to fill in his time as president. But some of it is also because of the Republican court packing that we've seen with regard to Merrick Garland being blocked in 2016 and Amy Coney Barrett being rushed through in 2020. I would favor adding 4 seats to the Supreme Court. Now, I realize the danger of that is that if the Democrats add 2 or 4 seats, the next time there's a Republican president and Republican Congress, they'll add 2 more seats or 4 more seats. But I think that's a risk that needs to be taken if we don't want to have a very conservative court for decades to come. But it's not going to happen.
Mark,
the reality is, if I could just add one more thing.
Please.
The reason it's not going to happen is that any bill to expand the Supreme Court or the lower federal courts will be filibustered in the Senate. The filibuster has been eliminated for judicial nominations and cabinet picks, but not for legislation like this. Already, some Democratic senators like Joe Manchin from West Virginia said they won't vote to eliminate the filibuster. And unless they do that, there's no way to get such a bill through Congress.
So, Mark, adding of seats, a good thing, a bad thing? And consider the point that Erwin just made. Let's just keep it real. Democrats in the Senate, in recent memory, have been outmaneuvered by Republicans in the Senate. So, do the Democrats want to go down this road?
You know, I teach constitutional law. Michelle and Erwin teach constitutional law. Every time I hear them, the first thing I think is, I am really shortchanging my students. And I need to get tapes of their classes. I think the answer to your question is this. I was listening in part to the confirmation hearings of Judge Garland, and I heard many Republicans speak very highly of his integrity. The same Republicans who would not even give him a hearing when he was nominated for Supreme Court. We started this conversation tonight talking about lies and dishonesty. When Erwin talked about the Detroit case and Michelle talked about so movingly about what moms would tell their children before their children were put up for auction. I kept thinking that that's how you change minds. You change minds by great themes. We the movement with respect to Detroit was exactly what we were saying. It was about an attempt to subordinate and disenfranchise a particular group, to keep them out of the American democracy and to not give them a chance. I think we need some themes in terms of what was done with the Supreme Court. What was done has absolutely no substance, no basis, no justification at all. I think we need to keep pushing on that point. And as the court starts reaching the decisions that it will this term and next term, I think we need to add to that story about what's happening, that this was a result of a deliberate effort to subvert the judiciary and the majestic role and possibility of the federal courts to address issues of justice. So, are we ready now to add to the court? No, I don't think so, for the political reasons that were laid out. Will we be? I think if we do our work, if we listen to the grassroots community groups that are out there, because they are about to do damage. They are, and they have been doing damage. But they in this era of COVID, in this era of inequity, built upon multiple inequities, they are about to make American lives that we cherish beyond statement in terms of having fair opportunities to define who they are. I think when those things start happening, if we start sending the message that that's what this court system has led to, and that's what this abomination in terms of putting a Barrett on for a Ginsburg in the same way a Thomas for a Marshall, I think we have a chance then, and I think that has to be part of the agenda as well.
So let's talk then about the role of the court and the judiciary in debunking lies. Michelle, it strikes me that court is still a place where you can tell a story where the other side has to be held to account for contradicting your story. In some of the cases in which we've had some successes, the SAT case, for instance, or in our litigation in Compton around the trauma, student trauma, we've been able to insert into the conversation facts about disadvantaged people, about people of color, that the larger conversation and the larger community is sometimes resistant to, in this world of Facebook likes. Is court a place where you still can get an audience for facts that perhaps won't get as many Facebook likes as they might if you're trying to tell your story in an extrajudicial circumstance? Is court still the place where we go to try to tell the truth?
It is. The sad part about that is that the court has not always been consistent in recognizing the truth. Right, so you think about a case like Plessy v. Ferguson. It's a case in which a Louisiana law is being challenged for its segregated nature, right? It is segregating people who are riding in train cars. And the challenge is brought by someone, your audience knows all of this, somebody who's actually 7/8 white, but still challenges it because we're a nation of hypo-descent, one-drop rule, whatnot. What's interesting about that case is the difference between the majority and the dissent. Where you have in the dissent, Justice Harlan is sort of predicting what will knowingly happen, which is that separate but equal actually won't be equal at all, despite the fantasy that's put forth by the majority in that court. And then you fast forward, across any number of cases challenging these separate but equal laws, and over again, Black people losing. And you fast forward again, and there are victories that come with Brown v. Board of Education, and after that, a number of these kinds of local laws, state laws, municipal laws being struck down, under this separate but equal, framework. And then you look at that within the context of sex as well, and look at that more recently in a case like Burr Wabi Lobby, where the Supreme Court uh, takes on the definition of what an abortifacient is based on those who don't want to provide contraception to their employees. The complete notion of what a pregnancy is based on science and health is actually not taken up by the court. The court actually conflates what these companies, Hobby Lobby and others, say that they don't want to cover. They say they don't want to cover abortifacients. And so they include these contraceptions as abortifacients, and they're not. It's an example where the Supreme Court's conservative majority says essentially, well, we agree with them, and it's far from truth. And yet at the same time, you see a corrective to that in Whole Woman's Health. It's a case that challenged two Texas anti-abortion laws, and you see Justice Breyer leading the majority opinion there. At this point, you have Justice Scalia is not on the court. He's passed away. And you see the court do a very deep dive in respect for an empirical record that's developed by the district court that helps to provide firm grounding for where the court then pivots, which is to strike down these two Texas anti-abortion laws based on fact, data, and evidence. But the court doesn't always do that. And I think that's one of the challenges, that it's a kind of push and pull, and we don't always see the conservative majority in these days doing that. And I want to just add one quick point, which is to say that we're talking about these issues as conservatives and Democrats. And then if we think about it, in 1973 with Roe v. Wade, in a 7-2 opinion, 5 of that 7 happened to be Republican. So I think part of this is also what has happened, right? The sort of Republicans of that time, and you think about something like abortion right, very different. You think of Prescott Bush was the treasurer of Planned Parenthood. So something significantly has changed. And I think that's an important part of the conversation about the courts when we're thinking about conservative and liberal, because the court has become somewhat partisan, right? It used to be that someone like Nixon could appoint someone like Justice Blackmun and you get a decision like Roe v. Wade. Today, that's very different.
So Erwin, if court is the place, the judiciary is the place where we go to have an honest hearing about facts, to Michelle's point, if there are participants in the judicial process who are held hostage by their own partisan instincts and their way of interpreting or reviewing facts, how can we not be held hostage by those partisan instincts on the court? We're dependent on judicial decision makers engaging in a fair and independent review of the facts. So what's the landscape look like for us?
We need to do the best lawyering we can. We need to do the most creative lawyering we can. We need to marshal the facts in the record. When Mark wrote the complaint in the Detroit case, it detailed the abysmal conditions in the Detroit schools and the lack of literacy. We need to present that to the court. That doesn't mean it's going to always succeed. The first question that I ask when I hear of somebody having an appellate argument is, who's your panel? We know that who the judges are is going to matter enormously. We also know, as others have said in this panel, throughout American history, the Supreme Court has so often failed. We're focusing on race from 1787 to 1865 when the 13th Amendment was adopted, a period of 78 years. The Supreme Court in every possible case protected the rights of slave owners in the institution of slavery. From 1896, when Plessy was decided, that Michelle refers to, till 1954. And that's a period of 58 years. The court articulated separate but equal and enforced the laws that provided for apartheid. And we talk about the terrible decisions of the Berger, the Rehnquist, and the Roberts courts with regard to race. So I'm not naive about this. Courts are going to often fail in this area, but sometimes there can be victories and dramatic ones. And I think they come by doing the best we can in lawyering, creative lawyering, and marshaling the facts for the courts.
I'm not naive either, and I'm hopeful in part and in large part because of the work of the three of you and folks like you. So let's talk about what you think may happen next. There has been a percolating conversation around reparations, for instance, and as much political steam as that issue may or may not gain, is that something that you think this federal judiciary could tackle or is likely to tackle? Certainly, let's just go off into, let's assume that there was political momentum for reparations. Let's assume that some version of that happened. These are huge assumptions. What do you think this judiciary, as it's now comprised, as it's now constituted, how might this judiciary handle an issue like reparations? That's a really big question, because saying this judiciary is also a big issue. But I'll just start with you, Michelle. How do you think the court's likely to handle these new creative political issues that are now being bandied about?
Well, thank you for that question, Tanya. And I was hoping that you're going to start with Mark, but I'm happy because we're going in order. Well, I think what's important about this moment is that it is there's the debate about when exactly the kidnap and trafficking of Black people began, right? So there are those that are debating, did it begin in the 1500s or was it the 1600s at 1619? But what's important is that we know factually it did exist. We've got the DNA evidence of it. We've got the evidence of people. And so that historic record, including that record from the Freedmen's Bureau, right? So when we're thinking about the robust empirical evidence telling a story, well, don't we have it? And we also have that legacy before the Supreme Court as well, with the various cases that had to come before the court, striking down any number of laws that prohibited Black people from having full inclusion in this country across myriad different areas. So amassing that evidence and telling the story, America's apartheid story, it's a part of our own truth and reconciliation, I think is important. In terms of that having leverage before the Supreme Court, it's doubtful. It's doubtful given the current composition of this court. Not doubtful because there isn't prior precedent for the United States providing reparations or acknowledging wrongs. The United States has not necessarily always been quick in any way to acknowledge it's wrong, but the United States paid reparations to former slaveholders. It also did that in the long wake of Korematsu. So precedent is there. I'm not confident in this court as one that would take seriously the dignity of African Americans. It's just, and I hate to put it that way, but it is the way in which, sadly, if one looks at cases that have come before this court that address the dignity of African Americans, even just very recently, the death penalty cases, as President Trump went on what some would call a killing spree before he left office, and with challenges making their way up to the Supreme Court allowing those executions to go forward, including one that took place on Dr. King's birthday, is really just chilling. So it's with that. I love the evidence that's coming forward, and I'm not confident about this judiciary at this time moving something like that forward.
Erwin, what say you?
I think I agree with Michelle's conclusion. The Supreme Court said, going back to Bakke in 1978, that there can't be race-conscious remedies for past discrimination. You can't use race to try to create a more equal playing field. The court said we can only use affirmative action for the sake of diversity. I think it was a terrible decision by the Supreme Court in not allowing affirmative action to be there for remedial purposes to overcome the long history of race discrimination. But at least the court allowed affirmative action for the sake of diversity. I think there are now 6 justices on the Supreme Court who are going to overrule Bakke and Grutter versus Bollinger and Fisher versus Texas and say that affirmative action is unconstitutional. The Constitution requires colorblindness. And if the court does that, then how would they be willing to uphold reparations? I hope I'm wrong in all of my predictions on this.
Mark, what do you say? Is there a path forward where perhaps you find the litigant that's able to draw the historical and factual connection to their family's labor having been stolen and created some great enterprise. Is there a path to reparations in this legal environment?
I think there is a path to a viable theory, but I can't disagree with Erwin and Michelle. And I think we have to be really careful as lawyers. Nobody's doing this existentially. You have to win these cases. And so I think you have to think about what Erwin just said, for example, in terms of the current race doctrine, which doesn't recognize systemic racism, which doesn't recognize even talk. When I last argued in front of the Supreme Court, I was asked by the Chief Justice, can't we just get past this issue of race? That's where they're at on these things. At the same time, again, without, you have to listen to the grassroots groups that are doing this, the community groups, the groups that are affected. You know, I often say to my students, if Linda Brown came into your office in 1900 and said, do you believe that separate is inherently unequal? You said, yes. Well, will you file a case for me in 1900? You'd know going in that that case was going to be defeated. At the same time, I think there are ways to talk about reparations. As you put it, Tanya, in terms of those linkages, I think every time there is a student of color who, for example, doesn't get an education and who then is out on the street having to fend for themselves, that student deserves reparations for a system of systemic racism that hasn't given that student a fighting chance. I think there are ways to talk about these stories. I think all of us have said, I think we can't get so demoralized about it that we run from the truth of those stories. But I think sometimes they will take some reconfiguring. And the answer to Erwin, obviously, in terms of what's about to happen in terms of race, is that we have to really fight that hard. We have to really say to the court, that is not acceptable. You cannot do it to these kids who literally didn't have a fighting chance to begin with. And you're now taking away this opportunity from them.
Mark, Michelle, and Erwin, thank you for this conversation. Thank you for letting me ask you these questions. You're heroes, and thanks for the work you're doing. I'm going to throw it back to my friend David. Thank you, everybody, for being here.
Thank you.
Thank you. I can't thank you all enough. It was an incredibly fascinating and insightful conversation. You were all terrific. Your informed comments, your insights, and thanks for participating. And Tanya, you, as always, were masterful. Can't thank you enough. Quick word, our next panel will be announced in the near future. We'll have a date and details coming up very soon. In the meantime, for more information on our series and to register for future sessions, please go to hourofjustice.org for more information how you can support public counsel with your time and treasure. Please visit